Hello, and welcome to another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services levels up your legal knowledge about an area of law that we practice in. Hi, I'm attorney Holly Webster, and I am the Equal Justice Works Housing Justice Program Fellow. Today, I will be explaining the process involved when you appeal an eviction decision from the Magistrate Court to the Circuit Court in South Carolina. But before we get started, we do want you to know this is not legal advice. It's just general information for the public. If you need the help of a lawyer, call our intake line here at South Carolina Legal Services or apply online. The information on how to do that will be provided at the end of today's presentation. While you're here on our YouTube channel, please hit that subscribe button and the notification bell. We want to be sure you always know when we post a video here on our channel. Also, be sure to check out our social media here at Twitter, Instagram, and LinkedIn. That way you can get all the up-to-date information we provide on our Level Up Law show and our other resources. Those websites and social media handles can be found on the last slide in today's presentation. So let's get started. As I stated before, this presentation will be on appealing an eviction to the Circuit Court. I do want to note that you can appeal beyond the Circuit Court. You can appeal to the Court of Appeals if the Circuit Court decision is not in your favor, but that exceeds the scope of this presentation, so I will not be discussing that in this presentation. I just want to put that out there. So the first question you may have is, what is an appeal? So an appeal is a request for a higher court to review and reverse a decision made by a lower court. The higher court in this case would be the Circuit Court, and you are filing an appeal to the Circuit Court so that the Circuit Court can review and reverse a decision that was made by the Magistrate Court. Because you are the one who is filing this action, this appeal, you are the appellant in this case, the one who is appealing the decision to the higher court. And the landlord, who was the plaintiff in the eviction action, is now the respondent in this action, which is the party against whom the appeal was filed. So the next question you might be asking is, why would someone file an appeal? Why do people file appeals? So you believe that you disagree with the Magistrate Court decision, and you believe that the court did something wrong at the Magistrate Court level. An example would be that the judge made a ruling that was not supported by the evidence. Maybe the landlord made a claim against you. They claimed, they made a claim against you and they did not have evidence to support that claim, but still the Magistrate Court ruled in the landlord's favor with no evidence to support that decision. Or you presented a lot of evidence to support your arguments at the eviction hearing, and the Magistrate Court disregarded that evidence for some reason and still ruled in favor of the landlord, despite all the evidence that was presented that supported your argument. Another example the judge did not apply the proper law based on the facts of the case. It could be that, they did apply a law, or they stated a law that was not applicable in your case, or maybe you made an argument and stated a certain statute, or to support your argument, and that was disregarded. Whatever your reason may be for filing an appeal, these are just two examples. So when can you file an appeal? Well, you can file an appeal within 30 days of the date in which you are notified of the magistrate court judge's decision. So the date that the judge ruled in favor of the landlord, when you were in court, that is the date that you were notified of the eviction decision. But if you want to remain in the dwelling unit while the appeal is pending, then you may not want to wait that 30 days. You may not have the 30 days before a writ is executed, and so you would file an appeal to the circuit court before the execution of the writ of ejectment. So before the set out date and time that is on the writ of ejectment, if you were served, and then if you want to stay, you just need to make sure that you file the appeal before you have to vacate the property. So what is the process for filing an appeal? You will need to complete and file what is called a notice of civil appeal with the circuit court, and I have included a picture of this document to the right of the slide for you to see what I'm talking about. And you can also find this document on the SC Court's website. I have included the link to the website so that you can click on it or so that you can view it in your free time, or if you want to stop this and look at it now, it's completely up to you. And the purpose of this document is to notify all parties involved in the action that you are appealing the eviction decision, that you believe that the magistrate court decision was wrong, that the court did something incorrectly or things incorrectly, and so this is just to let everyone else know what's going on. And so the notice of civil appeal, you will state who you are, or more like who you were identified as, but just so in the previous action, you would circle you were the defendant. You were the one against whom the eviction action was brought, and so you would circle defendant, and it says, you hereby give notice of appeal from the judgment of the magistrate's court in the above action. So the Circuit Court of Common Pleas in the county of whatever county the circuit court is in that you are filing this appeal, which is your county. And then you would state the date in which you were notified of the eviction decision. So when the magistrate court judge made their ruling, that's the date you would put in there. And then of course, they want to know, why are you filing this appeal? So you have all that space to explain whatever reason is your reason in your case. So Section 2740, 800 of the Residential Landlord and Tenant Act It talks about undertaking an appeal, an order, staying, execution. And subsection B of this section states that it is sufficient to stay execution of a judgment for ejectment that the tenant sign an undertaking that he or she will pay to the landlord the amount of rent as it becomes due periodically after the judgment was entered. So you may be wondering, what is an undertaking? So an undertaking is a written promise offered as security for the performance of a particular act that is required in a legal action. So your written promise, which you will see in the next slide, is a promise that while this appeal is pending, you are agreeing to make periodic payments to the court in place of rent. So that is your promise. That is the undertaking. And on this next slide, you will see a picture of the bond to stay execution on appeal. And this is your written promise right here. And I've included, you can find this document, of course, on the SC Court's website as well. And I have also included a link for you to view this document. It's important to note, and I put here 2740-800E, if the tenant fails to make a payment within 5 days of the due date according to the undertaking and order staying execution, the clerk, upon application of the landlord, shall issue a warrant of ejectment to be executed. So it's important that you keep your promise, this written promise, to make payments to the court while the appeal is pending so that you can remain in the dwelling unit. Because when you make this promise, that writ of ejectment that was issued against you when the magistrate court decision was in favor of the landlord, that writ will not be executed while the appeal is pending if you continue to make these payments. If you do not continue to make these payments that you are promising to make to the court, then you will not be able to continue with the appeal. The action will be dismissed, and you will need to vacate. A writ will be executed, and you will have to vacate the property. So it's important to keep this promise that you're making and acknowledge that it is a written promise. And that's why I explained what an undertaking was, so that you can understand what it is that you're filling out and providing to the court, a written promise. Now, this document, you will state the date on which the magistrate court ruled in favor of the landlord. You'll state the who, when, where, and how when it comes to paying your rent. And if you look at the bottom, so after you've filled out the applicable information at the top and you've dated it and you've signed your name, underneath where it says tenant, you'll see that last paragraph where it says, upon execution of the bond, execution on the judgment of ejectment is hereby stayed until the action is heard on appeal and decided by the circuit court. If tenant fails to make any rental payment within 5 days of the due date, upon application of the landlord, the stay of execution shall dissolve. The appeal by the tenant to the circuit court on issues dealing with possession must be dismissed, and the sheriff may dispossess the tenant. So what I stated earlier, it's once again given to you in the bond to stay execution on appeal, repeating the importance of making sure you understand what you are filling out and what will happen if you do not keep this written promise. Now, the fee for filing your appeal in circuit court will be $150. If you cannot afford to pay the filing fee, you can file with the court a motion, with the circuit court, a motion and affidavit to proceed in forma pauperis. And you can see that document to the right of the slide. I've also included a link to the SC Court's website where you can also find this document. And what you're saying is you cannot afford to pay the filing fee. You are asking that, you're requesting that the court waive the fee. And at the bottom, you can see here that the court needs to decide, of course, whether to grant or deny your motion. It is important to note that your appeal cannot be approved until this decision is made by the court. And so it's important that you keep that in mind moving forward, especially if you're limited on time. But just know that this is an option. If you cannot afford to pay the filing fee, you can file a motion affidavit to proceed in forma pauperis. And then you would, once you have completed the documents, you would make 3 copies of your completed documents, and you would take the original and your 3 copies to the clerk of court for the circuit court in your county. And the clerk of court will file the original documents and then timestamp the 3 copies. So now, one question that may pop up is, well, what do you do with those 3 copies that you made? Well, 1 copy would go to the magistrate court. So you take a copy of the documents that were filed in circuit court to the magistrate court. Then you would serve a copy of the documents on the respondent, the landlord. And the image that I have, it does indicate mailing, which is an option. If you are in a time crunch, you can also hand deliver the documents to the landlord, if that is possible in your case. I also want to note, if you're going to mail the documents, the address, you can look at the rule to vacate for the address of the landlord, the mailing address of the landlord, the lease agreement, just to be certain that the address that to which you are mailing these documents is correct, so that the landlord is properly served. And then, of course, you keep that 3rd copy for your record. Now, the magistrate court may schedule what is called a bond hearings, and the purpose of this is to determine the following. So whether you are current on your rent and how much you, the appellant, would need to pay to the court to keep the appeal going, to keep while the appeal is pending, so that it does not get dismissed and so that you can remain in the dwelling unit and not be evicted. If you miss the payment, as mentioned earlier, while the appeal is pending, then the action will be dismissed, and you will need to vacate the property. And just to reiterate, just to make sure it's very clear, the purpose of this bond hearing is not to go over why you believe that the magistrate court made the wrong decision, what they did incorrectly. That's the appeal hearing. So this bond hearing is to focus on rent, the rent situation, making sure that you are current, and if and to see how much you need to they need to order you to pay to the court while this appeal is pending. So I just want to make that very clear, that you don't think that if this is scheduled that this is your appeal hearing. Two separate hearings. And while the appeal is pending, the magistrate court will draft what is called a return. And what is that? A return is the magistrate court's response to the appeal. And it addresses what happened at the hearing, what evidence was presented, and I mean what testimony, your testimony as the tenant and the landlord's testimony at the eviction hearing, and then also what evidence was presented, what issues were raised, and then why, after all of that, based on the testimony and the evidence, why they made the ruling, why the magistrate court made the ruling that it did. And following this, and also to note, the return, the length of the return really depends on, the testimony. If there was a lot of testimony, if there was a lot of evidence presented, if it was a lengthy eviction hearing, if there was a lot that was said, if there were witnesses, all of this would need to be in the return. So just keep in mind, really no way I can't tell you how long the return is going to be. They all vary in size, so just keep that in mind. And it's followed by the evidence that was submitted at the eviction hearing. It's important to, since I am talking about the return and that addresses what happened at the eviction hearing, that that you raise all the issues that are applicable to your situation at the eviction hearing, that you present all the evidence that you believe will support your case. You want to preserve that on the record because you are limited to just all of that when you go to the appeal hearing. You cannot raise any additional issues. You cannot present any additional evidence. So just keep that in mind. Since I'm talking about the return and it's going back to the eviction hearing, just wanted to mention that important note. So what happens next? So you've already filed the appeal, you went to a bond hearing, you've been making your payments, keeping that written promise, you've been able to stay in your dwelling unit, and the magistrate court has drafted its return, you've taken a look at that, you've seen what the court's response to your appeal is. What happens next? What do you do now? Well, you wait, because the clerk of court for the circuit court will begin scheduling your appeal hearing, and I can't tell you how long it's going to take before you get a date and time for the appeal hearing. You just have to wait for it. Once a hearing date and time is set, both you and the respondent will receive a written notice of the hearing date and time. So you've waited and waited, and a hearing date was scheduled, hearing date and time was set, you were notified in writing, and now you may be wondering, okay, well, what happens at the appeal hearing? Generally speaking, you and the respondent will be going before a circuit court judge. Because you were the one who filed the appeal, the circuit court judge will address you, the appellant, first, and give you an opportunity to explain why you filed the appeal. So this is your chance to really just, yes, you did fill out the reason in your notice of civil appeal, but this is your chance to really re-raise those issues. Well, to first, of course, state why you believe that the magistrate court decision was wrong and what you believe that the magistrate court did incorrectly. And then, of course, you can raise the issues, again, that you already raised at the eviction hearing. And then and then, of course, discuss the evidence that was presented at the eviction hearing as well. This is your chance to really just go into everything and make that argument again that you made at the eviction hearing, in hopes that the circuit court judge will make a different decision than the magistrate court, will reverse the magistrate court decision, and that would be in your favor. And then, of course, the respondent will have a chance to speak after you're done presenting your case. And once again, you are limited to issues raised and evidence presented at the eviction hearing. So you have, it's also good to note at the end of the the appeal hearing, the judge may not let you know what the decision is right in that moment, and just take everything under advisement, the testimonies, the issues that were raised, the evidence that was presented and everything, and you'll get a response, the decision later. So you may have to wait, even after going before the circuit court judge, you may not get that decision right then. So keep that in mind. Once you do get the decision, one outcome would be that the circuit court reverses the eviction decision. So they disagreed with the magistrate court, and that's in your favor. They agree with you that the magistrate court made the wrong decision, that they did something incorrectly. This is what you're hoping for when you file an appeal. And if you were staying in your dwelling unit while the appeal was pending, then you will be able to remain in your dwelling unit. You will not be required to leave under this present action. So this is the outcome that you want. This is the best, the best outcome for you, the person who's filing an appeal pro se, or filing an appeal in general. Outcome 2 is. The other outcome would be that the circuit court affirms the eviction decision. So they agree with the magistrate court. They believe that the magistrate court made the right decision. So in this case, the decision would not be in your favor. You do have options. In this case, you can vacate the property, or you can appeal further to the Court of Appeals. But once again, as I mentioned earlier, at the very beginning of this presentation, before I really got into everything, although you can appeal further to the Court of Appeals, appealing at a higher level, that's beyond the scope of this presentation. I am solely talking about appealing to the circuit court. I just wanted to put this in there to let you know that that is an option if you would like to do that. Okay, and I have included a slide with additional resources. So I've included a link to our online classroom that we offer, and specifically the lesson on this topic in our online classroom. And at the bottom, when you visit this link and visit the online classroom, and you read everything, at the very bottom you will see a link where you can click on to view our pro se appeal packet, which includes the documents that I showed you earlier throughout this slide. And it also includes general instructions that you may find to be helpful moving forward. We really hope you do find these resources to be helpful moving forward. So that is an option if you would like to take a look at that. And I thank you for listening to this presentation and watching to the end of this video. So that concludes this presentation on appealing eviction decisions in South Carolina from the Magistrate Court to the Circuit Court. Now, if you found this helpful and you know it will be helpful to others, please give it a thumbs up and share it out. We want as many people as possible to get this important information. And be sure to tune in next week for another episode of Level Up Law on Tuesday at noon. And here, if you want to pause the video, you can take a look at our the information for applying for our services if you would like our assistance with your legal issue. You can contact our intake line or apply online at the link provided. We've also included additional resources for the general public. And thanks again for tuning in today on Level Up Law, and that concludes today's webinar. Thank you.